mean, who on any side of the political spectrum wants the courts to be interfering with what a private Catholic school is teaching?
It's like asking Rudy Giuliani to defend a perjury lawsuit. You say, what? He's the most perjurous person we know. And now we're asking Mark McCloskey to bring a lawsuit for white fragility.
Well, they call this the practice of law for a reason. You're exposed to something new every day, and I have never heard of a lawsuit under these facts using this theory before.
Similarly, Sarah, if Villa decided that they wanted to express concern for the police, I think they probably could post a thin blue line kind of flag or whatever this young person had on her computer.
They could do that.
Absolutely.
Yeah. Welcome to St. Louis on the Air. I'm Sarah Fensky. Now, we've talked on this show a bit before about Mark and Patricia McCloskey. They are the St. Louis-based attorneys who earned national fame, or infamy, you pick, for brandishing guns at protesters walking past their house this summer. They face criminal charges for that, although, as we discussed last month, Circuit Attorney Kim Gardner has been told she cannot prosecute them. She cited their case in fundraising emails, so a local judge kicked her off the case. Now, this month, the Missouri Appeals Court affirmed that decision. Unless Gardner appeals to the Missouri Supreme Court, Circuit Judge Stephen Omer will have to appoint a special prosecutor. But this month, for the first time I can remember, Mark McCloskey is in the news not for his role as a criminal defendant, but his role as an attorney. He's filed suit against Villa Duchesne, that's the Tony Catholic School in Frontenac. His client is an anonymous high school senior there. She is white. And he accuses the school of, quote, encouraging and facilitating race-based aggression against her. Does that suit have any chance of success? Well, joining us now to discuss that and much more is our legal roundtable. This month, that includes Bill Freivogel. He's a journalism professor at Southern Illinois University, Carbondale. Bill, welcome.
Hi.
And back by popular demand is attorney Eric Banks. He's a former state prosecutor and city councilor for the city of St. Louis. He's now in private practice at Banks Law. Eric, welcome back.
Hello, everybody.
And last but not least, this month, making her roundtable debut, is Sarah Swadesh. She's a partner at Sadeh Harper Westhoff PC. She specializes in employment law. And Sarah, welcome. We are so glad to have you here.
Thank you. I'm happy to be here.
So, Bill, I want to start with you on this one. What is the heart of this student's claim against Villa Duchesne?
Well, that that Villa violated its contractual obligations and inflicted emotional distress on this student by indoctrinating her and other students with critical race theory, suggesting that just because she's white, that she's racist, and that this not only violates Missouri merchandising law and contractual obligations, but also inflicts emotional distress. It doesn't take very long for the complaint to get into sort of the national debate about critical race theory. It was only, I think, about 2 weeks ago that the president's 1776 commission came out saying that critical race theory was racist and shouldn't be talked about in public schools. Of course, Villa is not a public school, but that's the claim.
So this claim, if you listen to some of the harumphing leading into this suit, Mark McCloskey seems to be painting this as a civil rights claim. You hear about disparate treatment and her race. And yet, at heart, this seems to be a contract law dispute. Eric, what do you think's going on here?
Well, they call this the practice of law for a reason. You're exposed to something new every day, and I have never heard of a lawsuit under these facts using this theory before. I would suspect it's going to be an uphill battle.
You think they don't have a good shot with this claim here?
I do not believe that the young lady, the anonymous Jane Doe, has a good chance of prevailing under these facts.
So, Sarah Swadesh, this suit alleges that other students at this school, quote, made threats of physical violence, including that this anonymous young woman, quote, needs to get smacked in the face, and they're going to, quote, jump her in the parking lot, but that the school didn't act when it heard about all of this. Assuming that these facts are true, as I think we're supposed to do when we read lawsuits, we don't know if this is the case, but let's just say Mark McCloskey's painting this accurately. Do you think there could be a contract claim here as he's trying to make?
I really don't. I mean, a contract, I read through the provisions he cites in the contract that it'll provide a safe environment and that there's going to be integrity and dignity for all students. How do you demonstrate that there's not integrity or safety? The girls never actually committed any violence against Doe. There were threats. I just don't know how they're going to prove an actual breach of contract. And I don't think those allegations are really intended to show a breach of contract. I think Mr. McCloskey is obviously trying to get to, have a more heated discussion about race relations in St. Louis. I don't think he's really intending to prove a breach of contract claim. And certainly not a merchandising act. He's claiming that education is a merchandise that he purchased. And that just sort of smacked me in the face of, no, that's not happening.
Bill, you work for a university. Have you heard about merchandising acts claims coming against schools? And does it matter at all here that this is a private school versus a public school? That's something I find myself wondering.
Well, no, I have not heard of a previous merchandising act claim against a school. I suppose I don't know whether any of those claims you remember when people were dismissed for the COVID thing and said they weren't getting everything that they had been promised. I don't know if any of those could have been based on some kind of merchandising claim. But you're right. This is a private school. I mean, you get to the last count of this complaint, count 5, and they try to make Villa into a state actor. They say, the Missouri Constitution protects you against racial discrimination, and to the extent that Villa gets some sort of public monies indirectly, it's a state actor. That just shows sort of how weak and extenuated their whole argument is.
We had some discussion of this case on our St. Louis on the Air Facebook group, and of the allegations that this student was allegedly force-fed an anti-racism message. Rich wrote this. He wrote, as an excommunicate who was in Catholic grade school in the 60s, it sure was force-fed in religion class, in social studies, and from the pulpit. If I were a judge adjudicating this, I'd rule that the plaintiffs have paid for this privilege to freely practice your religion. There's no violation of anyone's rights here. There seems to be some skepticism of these claims. Something else that I thought was so weird and fascinating in this suit. The suit says the student was, quote, held against her will and subjected to threats, coercion, and intimidation at the hands of defendants. She was not permitted to leave, was not permitted to contact parents or her attorney, despite the student's repeated requests to be permitted to do so. The suit says this is false imprisonment. Eric, again, this seems kind of novel to me. Do schools not have the right to meet with a student without their parents or say their attorney present? It seems like they're almost treating this like the school is a prosecutor in this case.
In my opinion, the schools do have that right. I cannot pronounce the legal theory that basically means schools, under some circumstances, can stand instead for the parents. One of the other attorneys may know what that phrase is, and more importantly, how to pronounce it.
Is that en loco parentis? I'm having
right.
memories from college. I was an RA. I just exposed myself right there. So they used to always talk about that.
Very good. Very good. Now all I have to do is learn how to pronounce it. But I think that the school is in safe grounds in terms of not having to meet with the parents and or an attorney.
And Sarah, if you think about this from sort of the 30,000 foot level, I mean, who on any side of the political spectrum wants the courts to be interfering with what a private Catholic school is teaching? I mean, I don't want to. I don't think if the McCloskeys would want to if you actually asked them.
I think that's a
straight
good
up.
point, Bill. Yeah. And Sarah, what's your thoughts?
Right. When I first read the lawsuit, it smacked me of white fragility. Fragility generally refers to the defensive stance that white people take when the topic of racism comes up. And in the lawsuit discusses the racism. Doe had a Blue Lives Matter sticker. The other students were talking about Black Lives Matter. Doe allegedly said Black lives don't matter. And that's what set off the whole ruckus between the students is blue lives versus Black lives. And the Doe student not recognizing her own white fragility and becoming defensive because she supports Blue Lives Matter and not recognizing that Blue Lives Matter is in direct opposite contradiction of Black Lives Matter. It has its own race connotation, and she doesn't recognize it. Blue Lives Matter was born out of Black Lives Matter. It's not a coincidence that they use the same name, and Blue Lives Matter is trying to control the narrative of Black Lives Matter. And so when I read this, I thought this is just white fragility. And then you put on top of it Mark McCloskey, who's the champion of white fragility.
He needs his
It's
gun.
like asking Rudy Giuliani. It's like asking Rudy Giuliani to defend a perjury lawsuit. You say, what? He's the most perjurous person we know. And now we're asking Mark McCloskey to bring a lawsuit for white fragility. I was a little bit dumbfounded, but maybe he's got a case there and maybe he's seeing something I'm not. I certainly haven't talked to the witnesses. I haven't talked to his clients, but they seem to go hand in hand to me.
So I'm glad you brought up this Blue Lives Matter sticker that she had on her laptop. She says it was actually a thin blue line sticker, but that has the very same connotations of what Sarah was just discussing there. It's associated with that same movement. I'm wondering, Bill, do you know, can a school just tell a student, this is divisive? You're not allowed to have this on your school laptop?
Well, yes, I think so. I mean, a school can tell someone you can't have a swastika on your laptop. We were talking, I don't want to jump ahead, but there's this Oakville high school case where parents were upset that a student came to school with a COVID mask that was of the Confederate flag. And once the principals found out about it, they took action, although actually the kid had already gone home from school, so it was a little bit moot. But yeah, you could. So a public school, even a public school, and certainly a private school, but even a public school can tell a person that they have to comply with a dress code and that they can't have hateful symbols on their laptop or their desk or anywhere else.
The students seem to try, she's making the argument that, hey, these administrators had Black Lives Matter material. Why can't I have my thin blue line sticker? Bill, you're saying a school, even a public school, can make that kind of value judgment.
Yes.
Eric, I want to bring it back to you here. Earlier, as we were talking about the McCloskeys, I mentioned that the appeals court recently affirmed the ruling that Kim Gardner can't bring the criminal case against them. And this is something where unless she can get the Missouri Supreme Court to overrule it, this means this is going to a special prosecutor. What do you make of all that?
I am concerned. 4 days ago, the St. Louis Post-Dispatch ran an article about the taxpayers in the city of St. Louis paying approximately $640,000 for special prosecutors. It listed 3 of the largest law firms that are the beneficiaries of that largesse. One of them earned over $500,000. According to their website, they have 14 attorneys, no African-American partners, 1 African-American associate who's not on the pleadings. Another law firm made approximately $150,000, over 100 attorneys, no African-American partners, 2 African-American associates, and the third law firm has approximately 40 attorneys, no African-American partners, 1 African-American associate. I believe that some of the special prosecutor opportunities should be divided in a more diverse and inclusive manner.
We need to take a break here in just a minute, but Eric raises a really interesting point. I mean, these judges are kicking off a black prosecutor that the people of St. Louis voted for. And it seems like, based on Eric's analysis here, they're replacing it with people from some lily white firms. Sarah, is there a problem with the way this seems to be playing out here?
I certainly think that there's an optics problem. These Kim Garner's who we elected. That's who the city elected. I understand that she sort of mentioned the McCloskey case in her fundraising appeals. I think that was unseemly. She shouldn't have done that. It wasn't a smart move. But kicking her off in lieu of what you call lily white law firms, I think it does have an optics problem. We'd like to know how the law firms were selected. I'm certainly not a fan of it.
And Sarah, it goes beyond optics in a situation where you had the special prosecutor investigating Gardner herself, and that was, I think Kim Gardner would say that was way beyond optics when they seized all of her records.
We do need to take a quick break. We'll be back shortly to continue this conversation. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU.
Support comes from the Missouri Forest Products Association, honoring Arbor Day on April 26th, with an ongoing commitment to sustainable stewardship and conservation of Missouri's forests. ChooseWood.com.
Welcome back. We're discussing some important legal issues today with an ace trio of attorneys. That includes Eric Banks of Banks Law LLC, Sarah Swadish, who's making her legal roundtable debut. She's with Sade Harper Westhoff. And we're also joined by Bill Freivogel of Southern Illinois University, Carbondale. We do have a listener who's interested in joining the conversation. I'm going to go to the phone lines. David is calling from Webster Groves. David, hi. You're on St. Louis on the Air.
Oh, yeah, hi. A couple of different things. I was struck by the discussion about the discrimination lawsuit at the private school. It's my understanding that there is a very clear case of if the school receives any tax dollars, they have to be unbiased. They cannot discriminate, and it's actually kind of creepy to imagine that a school like that would, even if it wasn't receiving any tax dollars, that they would pretend that discrimination was a smart idea. Discrimination is always backward thinking, and it's pretty preposterous. But, I happen to think of a second issue, and if I remember right, Missouri is a balanced budget state. And in an epidemic like we've got, whether or not a balanced budget actually denies the state the ability to save its own life, so that with some pretense that it can't do deficit spending, it cannot spend the proper amount of money to actually spend its own or to save its own life.
Okay, David, thank you for that. That's something I had never really thought about. Bill, quick thoughts on that?
Well, my thought on the Villa end of the question is that I just would want to point out that Villa certainly does not acknowledge, or would it in any way acknowledge, that it is engaging in racial discrimination. It denies all of this. And in fact, I'm sure that their argument will be that, contrary to the claim in the McCloskey suit, that what they are trying to do is teach balanced civil rights, history of the country. So I wouldn't accept that premise of the question. I'd also point out that the complaint did not cite any kind of federal funds or state funds that Villa was receiving. So I don't know that they are, and that doesn't turn them right into it's a much more complicated thing turning somebody into a private school into a state actor.
They'd have to make that case. They can't just come in. Yeah. It's not assumed from the judge's point of view that they're already there. Is that what you mean, Bill?
Yeah, right. And I mean, Villa, for example, can, based on or any other Catholic school can, based upon the religion, refuse to hire, Sarah, you can correct me if I'm wrong about this, but can refuse to hire gay or lesbian or transgendered teachers.
Right. And I think we're sort of blending the concept of private actor and public actor. Regardless of whether you're a private entity or the government, you can't discriminate. The Title VII laws, which prohibit race discrimination, and the Missouri Human Rights Act, which prohibits discrimination, applies to private employers, your company, and it also applies to the state. So regardless of whether Villa is receiving private funds, it can't discriminate. As far as the actions that they can take, because it's not a private entity, the First Amendment doesn't apply. The First Amendment only applies to the government. So the government can't show up my house and say, stop talking about the election, stop talking about your mayor. The government, the cops can't do that. But if I walk into Walmart, which is not the government, Walmart can say, we don't want to hear about the election. Just purchase your milk and go home. And so Villa is a private entity. Villa can have any restraints on speech that it wants or doesn't want. So if they want Black Lives Matter and they think it's appropriate, they're entitled to promote it. If they don't think it's appropriate, they're allowed to quash it. So Villa's not a public entity, yet the anti-discrimination laws will still apply to it under state law or federal law.
Okay,
Similarly, Sarah, if Villa decided that they wanted to express concern for the police, I think they probably could post a thin blue line kind of flag or whatever this young person had on her computer.
They could do that.
Absolutely.
Yeah. But it sounds like they've chosen not to do that. They have decided that what aligns with their message and their Catholic teachings is that they're in favor of Black Lives Matter. And Sarah, you're saying they have every right to do that.
They certainly do.
Okay. Well, this has been a good discussion. I feel like I've learned a bit, things I've never really thought about before. Mark McCloskey making me think. I don't know if I should be impressed with his legal writing here or going back to.
So.
Yeah. I mean, it's interesting reading different legal claims. Sometimes they're so well written, and other times you really kind of wonder what's up. Where are they going with this? Yeah. So. I want to talk about a different lawsuit that involves discrimination. In this case, we're talking about age discrimination. This was filed by a former meteorologist at KMOV, Megan Danahy. She was fired from that job. She says gender discrimination and age discrimination is why. She's 46 years old. Sarah, just the overview here, what would she have to do to prove an age discrimination case?
Sure. Well, I'll go through a few of the facts in case our listeners aren't aware of them. She was hired in 2014. In 2018, her supervisor came to her and said, we're going to move you from your meteorologist reporting times, which I think were noon and 5. They were going to take those reporting duties away from her and give them to Kent Earhart and Steve Templeton, 2 males. She complained to, I think, her union, and the supervisor said, okay, we're not going to take your reporting duties away from you, your reporting times. Airtime is important to them. They want to stay on camera. So he didn't initially take those times away from her, but began excluding her from meetings. I think he eventually gave her general reporting duties, and she says, I'm a meteorologist. I really can't go out on the street and talk about crime or traffic or, I'm a meteorologist. I know weather. So he begins to harass her, retaliate against her after she complains of discrimination. Fast forward to 2020, the summer, she files a charge with the EEOC. The supervisor leaves and she gets a new supervisor. I don't know what happened to the old supervisor, but he leaves. She gets a new supervisor, and about a month and a half later, she gets fired. And so her lawsuit is for age discrimination gender discrimination, and I believe retaliation. To prove a gender discrimination, age discrimination case, she's got to prove a couple things: that she was in the protected class, meaning she's a female over the age of 40. I think we all agree she can meet that. She has to show that she was somehow demoted or fired. I think we all agree she was fired. She's got to show that she was performing her job duties in a satisfactory manner. If we take the allegations and the complaint as true, then she would meet that burden. She says that there were 41 certified meteorologists across the company, and of the 41, she's the only one that had to go out and do general reporting duties. Sort of strikes you as, well, I don't know. But she's got to prove that she was performing her job duties in a satisfactory manner. And last, she's got to come forward with some evidence to show that she was being treated differently, or the circumstances show that she's being treated differently than the males or the younger people. I think she's probably going to rely on this argument that she was one out of 41 certified meteorologists who had her job duties taken away. Lastly, she's making an intentional infliction of motion claim against her former supervisor. I don't know if that's going to go anywhere. I would be surprised if it did. So I haven't talked to any of the witnesses. It's a well-written complaint, but I would certainly want to know the reasons for wanting to demote her. I haven't seen any performance evaluations. I haven't talked to her colleagues. I don't know anything about the weather. I can't tell you from watching the news if she was reporting the weather accurately or not. So I can't gloss from the petition whether she was doing her job, but it's well written, and so if I take it face value, it seems she's doing her job appropriately.
I would love it if the discovery included instances of when she said there would be a snowstorm and there wasn't. St. Louis weather, no one can get it right. But bigger picture, Sarah, thank you. That was a great analysis of this. Eric, hearing about all these age discrimination complaints filed by TV broadcasters over the years, this has been something that seems to happen a lot in this market. I'm thinking Larry Connors filed one against KMOV a few years back. There have been many others. Let's face it, TV isn't like radio. You can't be a middle-aged person like myself and maybe get the ratings sometimes. Station managers might conceivably want a young, attractive person in the anchor chair. Eric, you had talked about Hooters being able to hire for a certain look. Can TV stations do that?
I doubt it seriously. Hooters got away with it because, one, they settled everything before a judge or a jury had to make a decision. And they held out that looking a certain way was a bona fide occupational qualification. I don't believe that you can argue that being a attractive young meteorologist is a bona fide occupational qualification. I suspect to get the job, you have to have a degree in some type of science, probably meteorology, or at a minimum, you would have to have a college degree in journalism and transition perhaps from the general assignment desk to the weather desk. But I don't believe that they're going to be able to achieve either a motion to dismiss or a motion for summary judgment based on we have the right to hire attractive people.
Bill, do you think
And I
maybe...
think that-
sorry, go ahead, Sarah.
No, I was going to say that creates a bona fide job requirement. Do they really want to ask the jury who's more attractive, Megan Danahy or Kent Earhart? And they're not going to have, this isn't a religious institution. They can't claim that being a male is a bona fide job requirement. That doesn't make sense. I suspect what they're going to go to is they're going to say our viewers want to see, our viewers trust, and they're going to try to blame it on the viewers. The ratings show. But under the discrimination law, you can't engage in discrimination, race, age, gender, whatever it may be, through a third party, meaning, oh, my hands are clean. I don't mind African-American people, but but our customers don't want to get our suit tailored by the African-American gentleman. And that's a strange analogy, but you can't commit to discrimination at the request of your clients or your customers. And so I think KMOV coming forward and saying, well, our viewers want to see men. I think they're going to have an uphill climb, but I think that'll probably be their argument, because I don't get the sense that she wasn't performing her job well. I think the quote ratings will dictate.
Eric, it sounds like you agree with that analysis there from Sarah. She's got this one right.
I certainly do. And as far as I'm concerned, KMOV's only possible defense was she was not performing her job as well as other members of the staff who were not part of her protective class. Anything else is going to be a loser.
We do need to take a quick break here. When we come back, we're going to dig into some of the legal underpinnings of this bizarre battle going on at the St. Louis County Council. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU. Welcome back. We are talking today to our legal roundtable. That is 3 expert attorneys. We're joined by Sarah Swadish of Sadeh Harper Westhoff, Bill Freivogel of Southern Illinois University Carbondale, and Eric Banks of Banks Law, LLC. Now, I want to talk about this matter involving the St. Louis County Council, and this one's a little bit complicated, but I think it's really important to try to figure out what's going on here. Basically, the County Council voted for its new chair at the first meeting in January, and they re-elected Lisa Clancy. She's allied with County Executive Sam Page. This was a vote of 4-3. The problem is that one of the members who lost re-election got to vote in one of her very final days in the position. And the incoming councilwoman who defeated her at the ballot box, that's Shalonda Webb, was effectively disenfranchised from that vote. Webb was sworn in time for the next meeting, and then they went ahead and voted on this again. She threw her support behind a different candidate, that's Councilwoman Rita Days. The new council voted 4-3 to make Days its chair instead. But Clancy has refused to leave. She says that second vote was illegal. The county councilor's office, which is also, again, appointed by Sam Page, who's an ally of hers on the council, they filed a lawsuit against this new council majority. This legal action here, I hesitate to pronounce this because this is not something one hears about every day. It's called a quo warranto. Quo warranto. Bill Freivogel, have you ever even heard of one of these being used before?
I have heard the term, and I think I even wrote a story about one.
You are an expert then in quo warrantos.
No, I'm not an expert, but it's basically insisting in court that the person holding the position explain why they have the authority to hold the position. I mean, it's not saying that they've abused that they've acted improperly in the position. Just why do you have the authority to do that, to be the chair in this case?
Okay.
And so then the court will have to look at the law that each side presents.
So they took this action a couple weeks ago, trying to get this quo warranto. Frankly, I assumed this must be like a TRO, temporary restraining order, where we'd see really quick action. In the meantime, this second council that has this new chair, they have continued to take action. Is there a potential here that these council actions could find themselves challenged because of the fact that this is a council that may end up being invalidated?
I guess I think that's unlikely because I believe that Clancy just specifically said to go ahead and let Rita Days go be the chair for the meeting while the legal issue is resolved. So I think that was conceding that for that particular session of the council that they would go ahead with her as chair. So I think that would be a very weak legal argument for somebody to make, oh, well, this was the wrong person was serving as chair. That I don't think that will happen.
We talked earlier about some of the racial politics of Kim Gardner being forced off of being able to prosecute Mark and Patricia McCloskey. There are also some uncomfortable racial politics, I think, in this case, in that this faction that refuses to go is standing in the way of a Black woman who would be chair. And the voters who have maybe been disenfranchised in this vote are predominantly Black voters in North St. Louis County. Eric, does any of this give you any pause on this front?
Well, I certainly agree that it is a bad optic. Quite frankly, in my opinion, it does not pass the smell test, and I believe it's ill-advised.
I want to go to the phone lines. We do have some callers who have some thoughts on this one. Tom is calling from Afton. Tom, hi, you're on St. Louis on the Air.
Thank you. I have called my county council person, Ernie Trackus, and I will call again to say that I am just so frustrated that in the middle of the worst health crisis in 100 years, our county government is putting their time and attention on this infighting and rules minutia when they should be prioritizing the health of the county citizens. I just think it's an outrage. Thank you.
Tom, thank you for that thought. And boy, I've certainly talked to some voters who maybe share that thought. Sarah?
Yeah, that's my thought as well. When I first read about what's happening, it looked like a power grab, and I thought, shame on the county councilors who cannot figure it out. Because meanwhile, in Jefferson City, the Republican Senate, there's a Senate committee out there talking about imposing limitations on local government for COVID. So initially, the president of the United States said the governor will handle it. And then the governor said, all right, local's going to handle it. And meanwhile, in Jefferson City, we have a Senate committees talking about, well, OK, local government, we don't trust you. We're not going to let you impose limits on capacity limits at restaurants and 6-foot standing requirements and wearing masks and where COVID vaccinations can be given and who should get them first. So meanwhile, while our county councilors are arguing about who gets to be at the front of the line, like preschoolers, our government in Jefferson City is actually legislating real issues that are going to affect us locally. And so I have a feeling this will leave a bad taste in a lot of voters' mouths come next election.
I also want to just doubling on what Tom from Afton was saying about how frustrated he is by this and the point Sarah just made. It was in the newspaper yesterday, I believe, that now this council faction that has to defend the fact that they've got the majority and they're trying to rule here, they're having to hire lawyers. And they've now are trying to hire Hush Blackwell for a rate of up to $575 an hour. Is it naive of me that I'm somewhat surprised by that rate? Is that the going rate for attorneys in this town? Eric, is that what one should expect to pay for representation in St. Louis?
No, that's a little bit on the high side. I believe that according to the most recent report of the Missouri Lawyers Weekly, the average lawyer in Missouri, the partner, is billable hour rate is about $390 per hour. And if you look at the associates, non-partners, it's more like $290 per hour. So $500 per hour is on the high side. Now, it's probably in keeping with whatever that partner at Hush Blackwell charges their non-governmental clients. So it may not be excessive for a Fortune 100 company to pay, but it's steep for the county government.
Well, I hope they will negotiate a lower rate. If someone's listening, Eric Banks says that you can get a better deal here. We did hear from our listener, Dennis, on this matter. He says the court will pick the winner and the loser, but I think everyone involved lost in this entire circus. I want to bring it back to some other thoughts that we have heard from listeners. When we were previously talking about the Villa Duchesne case, we got an interesting tweet about this. And Joe writes, listening to your program today and about this lawsuit, which basically claims indoctrination. Well, isn't that what they signed up for? I mean, they are being taught a church's doctrine. I would think indoctrination would be expected, irrespective of whether you believe all of it. Thought that was an interesting and pretty good tweet there. I also want to go to the phone lines. We have a caller who I think is going to shed some light on something that I believe might also relate to the McCloskeys. This is Al calling from Ellisville. Al, hi, you're on St. Louis on the Air.
I'm not sure how much light I can shed on it. I just I thought I had heard that that some state legislator is introducing a bill to make it a crime to protest.
I think there are a number of bills that seem to be headed in that direction, Al. Yeah. Are you concerned about a particular one or the overarching theme here?
Well, they're saying that if you block the street, which protesters have done in the past, that's considered, I guess, a felony offense. Also, if you go on a private citizen, if protesters go on private citizens' property, they have the right to shoot and defend themselves. I think it's an overreaction to the McCloskey event.
Yeah, Al, thank you for that. I appreciate that. I think, this is one of these bills that you could name after the person who inspired it, the McCloskey bill. Bill?
Yeah, this was I think there was a story in today's front page of the Post-Dispatch about these bills. One of them is proposed by a Republican representative or a legislator from, I think, Harrisonville, and it would make it would say that a motorist who was blocked by a protester could not be held liable if they drove their car into the protester.
How could that hold up with the First Amendment? Am I crazy that it feels like the Supreme Court or maybe some court before we get there is going to have some issues with that?
Well, I hope some court does, but I mean, a protester does not have a First Amendment right to block a person's car on a street. So the protester can't exactly, doesn't have a free speech or free protest claim there. But still, I mean, I certainly hope we don't pass a law like that.
Sarah, this seems to come back to your point about all the big issues that Missouri has right now. I know we're like 50th in the nation in terms of vaccine distribution, and yet it seems like some people in Jefferson City want to fight some of the battles of last summer.
I think that's right, and I guess my thought is protesters. Do they have permits? I mean, I look at Charlottesville and the white neo-Nazi counter protester just ran over the African-American woman, just ran over a horde of people and killed one. I can't fathom that person wouldn't have criminal liability or civil liability. That's just shocking to me. I think our county council office has a lot more important things to be doing than arguing who should be in charge. We have COVID. COVID vaccines aren't available. I know people traveling down to Cape Girardeau. Can you imagine living in St. Louis City and saying, wow, Cape Girardeau is more progressive than we are and they have more vaccines? But I know somebody who's driving down there on Thursday or Friday. We have a lot more important issues than who should be the chair. I mean, I understand all politics is local and whose chair is important, but on the scheme of things, I'm probably not the lone person who would say I'd like to see a more policy.
One of the bills that Sarah mentioned before about taking away local power, county power to issue COVID health regulations, that was proposed by Andrew Koenig, I think is the way you say his name. He's a Republican senator from St. Louis County, and as a matter of fact, I think he's my senator. And I think he recently announced he got COVID.
That's right. Yeah, he did. But, his body, his choice, right? Bad joke there. Sorry, guys. Okay, I'm going to bring it back to dysfunction in St. Louis County, what I might frame as dysfunction in St. Louis County, at least. This is an employment matter. This involves a guy who previously won a big jury verdict against the county. A jury found that police officer Keith Wildhaber was repeatedly passed over for promotions because he was gay. The jury awarded him nearly $20 million. St. Louis County then finally promoted Wildhaber. They put him in charge of a new diversity and inclusion unit. It's after that this most recent thing happened. A police dispatcher was caught on tape using a terrible racial slur. Reporters learned about this. They reached out to Lieutenant Wildhaber, again, the head of the diversity and inclusion unit. He gave a basic statement condemning the use of racial slurs. They ended up issuing him a reprimand. How is this appropriate? What's going on here, Eric? Any thoughts on this?
My office mate is the newest St. Louis County Police Commissioner, so it probably would not be appropriate for me to comment.
Well, that is fair. Thank you for disclosing that. Sarah, let's go to you.
I would like to see what the reprimand is for. Is the reprimand for, you should have fired the guy and you didn't? Is the reprimand for, we have a policy of only public statements come from a certain office or a certain official,
So
and you're speaking outside the chain of your command?
Yeah.
So I would like to know
exactly
more
what it
about
is.
why he was reprimanded.
So the department has issued
That he shouldn't.
Sorry. The department says, quote, only the chief of police or designated representative may release information regarding department policies, administrative activities, or internal police matters to the news media. Do you feel like the department has every right to discipline him then in light of that? Bill, I see you jumping in there.
Well, I think they probably do have a right to, but I'm a journalist. These policies make me really unhappy. I want to talk to the person. If I'm writing a story about discrimination claim in St. Louis County Police, I want to talk to the person who's the head of the discrimination office. And what do I think if I call that office up and they say, oh, only the chief can talk about this? They're just trying to hide the ball. Of course, the chief here was the sister-in-law of the person.
The chief is the sister-in-law of the man who used this racial slur, is what we now know. But Sarah, you're saying
that's not a good look.
It's not a good look at all. And Sarah, I know you agree it's not a good look, but you're saying legally they can do this. They can reprimand him.
Yeah, and I don't necessarily, even though I want a free press and I want information to come out and I want things to be transparent, I also understand the rationale. Imagine if you are Jeff Bezos and you have Amazon or Walmart and you have 100,000 employees. We need a unified message to come from the company. Just because you are the manager at the Walmart in South County, it doesn't mean you're speaking on behalf of all of Walmart. And so I think it's a fine line between, this is my personal opinion. It's not necessarily the opinion of the company. And so if Mr. Wildhaber had said, I find this reprehensible, I don't use this language, and I don't like it in my personal capacity, I would say that's fair. I think it's absolutely fair. You shouldn't and can't discipline for his own opinion. But I don't know at what line that crosses, because the company, maybe they're going to fire this guy, maybe they're not going to fire the guy, but it's the company's decision. And I understand he's the head of diversity and inclusion, and I agree with his opinion. But if he doesn't have the authority to speak, then he shouldn't speak on behalf of the company. I wouldn't want if you own a company, you wouldn't want your secretary or janitor speaking on behalf of the slip and fall that they saw in the parking lot.
So, Bill, Sarah's making a really good case here. Now, the part of me that is trained as a journalist, I
You're
love
on my
it.
side, Sarah.
I like it when people go rogue.
No, I love it. I want people to talk to me. I want to understand what happened, but I understand from the company's perspective that they need to have some reins on. All right, it's why the president of the United States has currently has, didn't used to have the press secretary. Mm-hmm. There's one person in charge.
Well, okay, I understand your point, and you're probably right as a legal matter, but I think that if you're the head of diversity for the St. Louis County Police, and you have responsibility for making yourself known on a serious issue of racial hostile work environment created by the chief's brother-in-law, and so I respect him for doing it. He could take. I think he left. I think he quit, didn't he?
He has been trying to get out of this role. Yeah, I don't know if they've officially relieved him of his duties here, but I mean, the poor guy.
I have a lot of.
I think ESOP. I think the Ethical Society of Police have brought that up. Just because the guy won a big jury verdict, why is he in charge of diversity and inclusion now? So I think, maybe it was a good fit, maybe it wasn't. And I respect his opinion that he found the racial slur to be wildly inappropriate. But as you said, his job is to ensure diversity and inclusion his job isn't to be press secretary.
So on that note, unfortunately, I do have to cut in here. We are out of time on today's show, and it's killing me because we had so much else we needed to talk about, but there's too much happening in St. Louis, I'm sorry to say. And I have really enjoyed getting to talk to today's panel. Sarah Swadesh, A Star is Born. Thank you so much for joining us and making your Legal Roundtable debut.
I was happy to be here. Thanks for having me.
And Sarah, again, is a partner at Sadeh Harper Westoff. We were also joined by Eric Banks, who, once again, it just has such a good way with the quip. Eric Banks of Banks Law, LLC, thank you so much for joining us.
Thank you for inviting me back.
And Bill Freivogel of Southern Illinois University Carbondale, one of the OGs of the Legal Roundtable. Bill, thanks again for being here.
Thanks.
If you learned something new from today's episode, consider leaving us a review and rating on Apple Podcasts on the App Store. It's the easiest way to help people discover our show. We appreciate it. Thank you.
Support comes from the Missouri Forest Products Association, honoring Arbor Day on April 26th, with an ongoing commitment to sustainable stewardship and conservation of Missouri's forests. ChooseWood.com.